Maryland is asking a federal judge to keep the state's gun permit law in place while they appeal a ruling that it's unconstitutional. State officials filed a motion Wednesday asking Judge Benson Legg to stay his ruling in the interest of public safety. Earlier this week, Legg ruled that the current law, which requires a good and substantial reason to carry a firearm, infringes on the Second Amendment right to bear arms. Delegate Michael Schmiegel touted the ruling, saying it's the same argument he's been making for years. Schmiegel, who has a permit to carry a concealed firearm, currently has a bill before the General Assembly. It would allow people who have been issued permits in nearby states to carry guns into Maryland.
The interpretation was the Second Amendment applies, but they were saying, well, only in the home, the local authorities. Now, the Maryland decision, Judge Legg clearly said that the Second Amendment applies outside the home, and that the standard that was used is an arbitrary, capricious standard by the Maryland State Police, which is a good and substantial reason. And the citizens, if they did not have mental illness, alcohol abuse, a felony conviction, or the use of drugs, or have a propensity for violence, if you had none of those disqualifiers, then you had to go on and show, in addition, you had a good and substantial reason. The court ruled that the Second Amendment is enough.
And Judge Legg made his decision based on a case involving a man who was denied a permit renewal in 2009 because he could not show that he was subject to threats beyond his residence. Plaintiff Raymond Woolard obtained the permit after fighting with an intruder in his Hampstead home in 2002.